Hi, this is the second of your training videos for HIPAA with Dental Masters.
Some of the things we're going to be covering are an overview of what communication is, some of the HIPAA guidelines, do's and don'ts, and what secure communication actually is. So let's get into the nitty-gritty. What is HIPAA? Well, HIPAA is protecting the privacy and security of health data. It requires administrative, physical, and technical safeguards be implemented to address the confidentiality, integrity, and availability of protected health information and electronic protected health information, or what we refer to as EPHI. Protected health information is used to identify a patient and can exist in written, oral, electronic formats, including demographic information. It may describe past, present, or future physical, mental health conditions or payments for the provision of health care. A proof of good faith efforts is what's needed to be able to show that we have made every effort to be as up to date and HIPAA compliant as possible.
So who does HIPAA apply to? Well, let's start with us at Dental Masters. We are a covered entity. We're healthcare providers in this instance, but it could also be a health plan, a healthcare clearinghouse, anybody who electronically transmits any protected health information. It could be a business associate, such as a lab, any individual or organization that creates, receives, maintains, or transmits PHI on behalf of a covered entity. Or it could be a subcontractor, somebody that a business associate hires out for themselves who can create, receive, maintain, or transmit PHI on behalf of them.
In short, the security standards or general rules allow for HIPAA security standards to ensure the confidentiality, integrity, and availability of protected health information that is created, received, maintained, or transmitted electronically by and with all facilities, to protect against any reasonably anticipated threats or hazards to the security or integrity of such information, and to protect against any reasonably anticipated uses or disclosures of such information that are not permitted. We talk about communication in all kinds of manners, but what is communication when it refers to HIPAA? It's a process by which information is exchanged between individuals through a system of common symbols, signs, or behavior. Communication in dental practices is much more than it was even 20 years ago, and it continues to evolve. Your phone, texting, social media, one-on-one time, the methods of communication are growing. The Department of Health and Human Services describes privacy as the patient's right over the use and disclosure of his or her own protected health information. Privacy includes the right to determine when, how, and to what extent protected health information is shared with others. So during the course of your job, except in connection with patient treatment, once again, you always use just the minimum necessary information. So after work hours, you're not talking about or communicating electronically about a patient's health information. You're not using their name when speaking about them with regards to their health. You can be social with a patient, but never use their protected health information for personal gain. Keep patient information private, use it at a bare minimum. That is your professional obligation. I have a question that comes up often, and I want to address it now. If someone calls the office to verify if someone is a patient, you may say yes. However, you can't say anything else without proper forms, releases, and confidentiality agreements or a business associate agreement. Protected health information can be shared between covered entities and a covered entity that has a business associate agreement in place. When HIPAA permits the use or disclosure of any protected health information, we only provide the minimum amount of information necessary to accomplish our goal. The only exceptions to the minimum standard are treatment, purposes for which authorization is signed, disclosures required by law, and sharing information to the patient about him or herself. The Department of Health and Human Services have come up with 18 identifiers that apply to anybody who is being seen in the practice. Those 18 identifiers are any names, any geographical subdivision smaller than a state, all elements of dates except for the year that directly relate to an individual, which might include their birth date, admission, discharge date, or their date of death, a phone number, a fax number, an electronic mail address or an email, social security numbers, medical record numbers, health plan beneficiary numbers, account numbers, any certificate or license number, a vehicle identification or a serial number, including license plate numbers, any device identifiers or serial numbers that might have a patient's information on it, a URL or a web address that might have a patient's information on it, an IP address, including the numbers, any biometric identifiers, including finger and voice prints and retinal scans even, full face photographic images or any comparable images, and finally, any other unique identifying number, characteristic, or code that somebody could use to identify a patient. Those are the big 18 identifiers. The HIPAA rule requires that we de-identify a patient, meaning we must remove any and all of the 18 identifiers before we let that information out of our hands. So let's take a little overview of HIPAA. It is compliance versus security, meaning fines versus risk. The two are not the same. HIPAA and high tech are two totally different things, but they apply similarly to a dental practice. They both protect patient confidentiality while furthering innovation in patient care. It's the privacy and the security rule. High tech has to do with the security, HIPAA with the privacy. The omnibus rule was the final rule that says that business associates must also work towards HIPAA compliance, that there's a breach notification rule in place, and that covered entities must have a business associate agreement in place before and while doing business with an associate, and that we all conduct our technical due diligence to make sure that in the transmission of information, there isn't a possibility for a breach. A little more about that omnibus rule of 2013. It says that business associates have direct liability by functioning as our business associate, and that they can be liable for violations, that they must be HIPAA compliant in the security rule, making sure that the technical, administrative, and physical safeguards that any covered entity might have in place is also in place for them. And that covered entities be in compliance with the privacy rule, maintain those business associate agreements, and that we make sure that our business associates are doing their job as well.
So let's talk really quickly here a little bit more about compliance versus security. Compliance means we are creating and conducting audits regularly to check and make sure that what we're doing meets the minimum standards, that we're looking for gaps and identifying them so that we can remediate them, that we write specific policies and procedures for dental masters that apply to not only dental masters as a company, but to our individual offices, because they all function separately and a little bit differently from one another, that every employee is trained so that they know how to handle protected health information and also what their liability is, that we keep those business associate agreements current and that we audit them regularly, and so that we know how to manage an incident should it occur, and they do occur. Whereas security means we're doing risk analysis, we're doing penetration testing, we're having our IT company make sure that our firewalls are protected, that we are remediating any of those vulnerabilities that are found, and that we are protecting and hardening our systems so that we can prevent problems down the road, and that we have detection monitors in place. Once again, risk versus fines is compliance versus securities. To be in compliance with HIPAA means that we are meeting their minimum standards of implementing policies and procedures and how we conduct ourselves, of designating a compliance officer within each of our practices, by conducting training and education and keeping everybody up to date, by developing effective lines of communication and conducting internal monitoring and auditing. We have to enforce standards through well-known disciplinary guidelines, and we must respond quickly to any detected offense and undertake corrective measures immediately.
There are many types of data that are protected by HIPAA, and that data can be stored either as paper charts, it could be having conversations on the phone, removable devices, photographs, your computer networks, and even audio files. When it comes to patient privacy, the Department of Health and Human Services cares about two things. Did you show good faith? Did you show good faith in trying to protect a patient's information, their confidentiality? Or were you neglectful? Did you walk away from a computer terminal without signing out? Did you purposefully discuss a patient's information and let anybody hear it? Did you send information over an electronic means without the proper protective parameters in place? Did you show good faith? Did you do your best to maintain the privacy of the patient, or were you neglectful? Because of the 2013 Omnibus Rule, the Department of Health and Human Service is now required to investigate and impose federal civil penalties where violations are due to willful neglect, and they have up to 6 years from the occurrence in which to initiate that investigation and those penalties. The state's attorneys general can pursue civil cases against individuals, so individual workers under the umbrella of a company. Civil penalties now also apply to business associates of a covered entity. If you look at the diagram here, it will show you that there are 4 tiers of penalties. The first tier is that the covered entity didn't really know and couldn't reasonably have known that a breach was going to occur. And those fines can be up to $100,000 to $50,000 per incident, to a grand total of $1.5 million. The second tier is where a covered entity knew, or by exercising reasonable diligence would have known of a violation, though they did not act with willful neglect. Those penalties begin at $1,000 and can be up to $50,000 per incident, to a total of $1.5 million. The third tier, however, starts at a penalty of $10,000 per incident, up to $50,000 per incident, with a total of $1.5 million. That third tier shows us that when a covered entity acted with willful neglect, but corrected the problem within a 30-day period, they would be fined those penalties. Finally, the fourth tier is when a covered entity acted with willful neglect and failed to make any timely correction. Those are $50,000 per incident, up to a total of $1.5 million per incident. Wrongfully assessing or disclosing PHI, obtaining PHI under false pretenses, or wrongfully using PHI for commercial activity by an employee can mean that they can go to jail and they can be assessed the fines. Can you think of some examples that would constitute an offense for each of these? Let's take, for instance, somebody who might sell Tupperware. If they accessed patient information in order to send them an invitation to a Tupperware party, that's wrongfully using PHI for commercial activity. But before you become too concerned, know really that they're looking for wrongful intent and negligence. Once again, showing good faith effort is important, and how you set about rectifying your mistake or that of an employee if you're the boss or compliance officer really does matter.
Use and disclosure forms that are provided to patients from dental masters cover the ways in which we may communicate with them, whether that be text, voicemail, email, regular mail, and it also covers patient testimonials.
We need to let the patients know just how we plan to use their information and if it's okay with them. Under the HIPAA and high-tech rule, electronic patient health information requires that we use encryption services for websites and emails, and that if we're using a cloud-based service, we have a business agreement on hand for that associate, that we keep computers locked when they're not in use, and know that if there's an accidental breach and the necessary steps are in place, it's not automatically a fine. So what constitutes a breach? Well, the first thing is failure to log off of a workstation. You are required to log off of your workstation, whether it's up front, in a hallway, or in an operatory when you're done using it or when you walk away. You are not allowed to share log-on information and work under somebody else's name while on a computer. Another breach would be unauthorized access of protected health information. Sharing confidential information, including passwords, having patient-related conversations in public places, the improper disposal of patient information in any form, be it a paper chart or a sheet that was generated from the computer, copying and removing PHI or ePHI from appropriate areas. So you're not allowed to download onto a removable disk or jump drive patient information without prior authorization. Why do these things happen? Well, sometimes a breach occurs because we're curious about a coworker or a friend. Maybe we're lazy and shared that sign-on at a workstation, or we felt compassion, the desire to help somebody, and finally, greed or malicious intent to look at patient health information for personal gain or just to hurt someone. Some examples of a breach would be Bill gets a bill and he's a business associate. Now, is that a breach? Well, no, it's not actually, because Bill is a business associate and he got some information that he should not have received, but because he is a business associate of ours, he's covered. Another example would be Rhonda, who doesn't have proper authorization but accesses a friend's file. That is a breach. She was looking to get information on a friend but doesn't have authorization to do so. Rob, who's an assistant, takes a thumb drive to continue work at home. This could go either way. If Rob was given express permission to take that thumb drive and work at home, or take that laptop and work at home, that's fine. However, if he did it just on his own without authorization, he is in breach. Let's think about what could have happened. Perhaps Rob lost that thumb drive and somebody picked it up and was able to access social security numbers and addresses of patients from that thumb drive. That is a serious breach that could damage a patient in some way. Perhaps Rob decided to continue his work from home with that thumb drive, but his computer at home did not have the proper firewalls in place to protect the patient's information. Once again, that is neglectful and that is a breach. Not only is the covered entity liable, but so too is Rob for any fines that might be imposed if a report of a breach has been made.
Because protected health information is fluid, we are always working towards maintaining compliance when it comes to the rules and regulations that the Department of Health and Human Services has set forth to protect the information of our patients and the privacy that they expect. Dental Masters is committed to this, and by training you, we expect all employees to be committed to this as well. Should you have any questions, or should you notice a breach or a potential breach or an area that could be hardened, and protect our patients' information further, please bring it to our attention. Thank you very much.